Hello and welcome to Edukemy's YouTube channel, an editorial discussion for 13 May 2022. My name is Harsh Singh, and in this video we shall discuss an editorial from yesterday's Indian Express which is titled A Small Win. This editorial speaks about the very much popular these days IPC section 124A, which is also commonly called as the Sedition law. The article primarily speaks about the Supreme Court interim orders and what are the issues related with it. If you like this initiative, share some love through likes, shares, and subscribes. This editorial is important from the perspective of GS Paper 2, that is governance, and GS Paper 3, security issues in the country. Now, uh, this time the sedition law IPC 124A is in news not because of a particular case but because it has been challenged in the Supreme Court. It has been challenged many times before, and this time the Supreme Court has asked the central government to give what is its say on the sedition law. Earlier, some central government has been defending the law, but lately the government has said that we would like to reconsider the law if at all it is draconian or it needs some kind of amendments. Now, this is where the court must factor in the pending cases. Now, there are many cases in which people have been languishing in jails pending trials or appeals, and this must be considered. And if there is continued misuse of these provisions, and this should be considered, because when the law is being considered, when the central government wants certain time to consider this law, what about the people who already are pending these trials? What happens to them? So the central government says that for the new cases, we will have, see, these were the deliberations happening in the Supreme Court. So the representatives of the government said that we will have at least one SP, superintendent of police ranked officer, who would justify if any new case is being registered in IPC 124, a sedition law case, and it will also be under judicial scrutiny. This is what they said. Then the appellant, people who wanted the sedition law to completely go, they said that this is not what is required. We need the suspension of law in totality till the time the central government makes what is the reconsideration of this law. Till the time you abolish the law completely, because it might have some ill effects and it might be misutilized by the government. So stay on all the pending proceedings and bar any new registration of cases. This is what the people have asked for. But Supreme Court did not take the stand of the government, did not take the stand of the people. It went ahead with its own stand, saying that the assuming that the center and state will show restraint in new sedition cases. So they will, this is one assumption. The second one is, it says that the lower courts will be requested to examine the cases in case people need acquittal or bails, or people do not need arrest under 124A. So now it has been left at the discretion of the lower courts if new sedition law, if the new sedition charges will be imposed on anybody or not, till the time central government gives an opinion on it, right? So accused and or the victim themselves who could be accused will be at the mercy of court. This is one issue here, right? The only absolute judgment that Supreme Court has passed right now is that there will be stay on all pending trials which are in the courts, any of the courts, they will be stayed upon. But now, in case the people have appealed, what happens to them? In case the proceedings are happening now, these are the proceedings in which people would have wanted bails. It is happening against the people right now. How are we providing relief to them? So Supreme Court actually should have, according to the author, should have actually given an absolute statement saying that the law should be suspended till the time central government is reconsidering it. Okay. Now, the conclusion of this editorial says that this particular provision of sedition law, it can be misused in many forms. For example, even if the Supreme Court says that the law must be withheld right now, suspension of the law right now, even then, many executives might misuse it, just like they misuse the provisions of 66A of IT Act. When this provision was cut down by the court, even then people were put behind bars in this. There are provisions in Unlawful Activities Prevention Act, National Security Act. All of them speak about non-bailable provisions for people who have been registered under these acts. So even if sedition law goes, then also UAPA, National Security Act, many such acts are available with the government, and they can act as a way in which they can be misutilized. So let us quickly understand what this sedition law 124 is about. It is also called as Deshdroh in Hindi. Now the IPC section 124A simply states that if one has spoken something, written down something, or has had visible representation by signs of anything which is bringing contempt or hate to the government which has been established by law, or excites disaffection towards that particular government, it can be punished with imprisonment or of life or fined as well. That means anybody who is showing contempt or criticizing the government and could be put behind bars under sedition law, under Deshdroh. So this is where the Kedarnath case has also given some relief. This is a very draconian provision, right? Anybody can be imprisonment if they are criticizing the government. So the Kedarnath versus State of Bihar 1962, one of the most important provisions which is securing the fundamental rights of people, is that it says that if anybody is criticizing the government, it is not a problem at all. But any such criticism or anything that is inciting violence or has intention or tendency to create public disorder or public peace disturbance, this will be the criteria for sedition law. If in case you are vandalizing the public property, then there will be laws imposed on you. If you are acting against the national symbols, for example disrespecting the national flag or the national anthem, there are laws for that. But then if you are inciting violence, or if you're disturbing public peace or creating public disorder, then sedition law can be imposed on that particular person. So this is an important criteria for holding a person accountable under sedition law. Otherwise sedition law, just merely criticizing the government, will not apply. So important measure to protect the rights of the people. This is the sedition law on which the people have said that the government is misutilizing this law. It is taking advantage of a law against the people. So this law must be removed right now. Right. So this is the update. Now the one reality behind this law is that the law has got decent level of protection for human beings, for all the persons in the country, but its execution is not proper. The police goes and catches any individual and captures them under sedition law. However, when the court scrutinizes the details, it realizes that the court scrutiny does not stand the ground of what police has said about the person, and many of the people have been released under sedition law. So this is the appeal, that sedition law must go away because it is being misutilized by the government authorities. All right. So a quick update that I seek from you: mention three issues with sedition law and its governance. Quick question, small question, will exercise your brain. And if you like this initiative, share some love through likes, comments, and shares. You got some questions, put it down in the comment section, and we will ensure to get back. Thank you for watching.